thought I'd go ahead and make one more video. I got a series of videos, y'all, when I'm talking about this power of attorney, the presumption of death, and how this stuff actually ties right in with the Cestui Que Vie Act. Go look at my previous videos. I'm not going to talk about the Cestui Que Vie Act on this video, but I am going to show y'all. I've been talking to people privately who's talking to me for the first time on the phone who don't know where the fuck these people get power from to do what they're doing in the courts. And I stop them right there and I give them homework to watch the video that I posted a few months ago called "Where Does Their Power Come From?" If you haven't seen that video, you might want to stop this video and go look at it. Okay, it is very detailed, and I thought this is, it's very detailed. It shows you how those powers of attorney that they create when you're born, it controls every aspect of your life. They can delegate different powers to different agents to act on your behalf, starting with that power of attorney. And I always tell you that this is exactly where it starts, is when you're born. When your mother signs a prenatal agreement, I'm saying that right, yeah, a prenatal consent form. It's an agreement where she actually grants the physician to do things on her behalf, or on behalf of the baby, during the pregnancy. Every woman that you talk to, every woman watching this video can have a flashback about that. They know that they signed. That you signed. All ladies who are watching this, you remember signing, consent forms when you first realized you were pregnant, that you're missing your period or whatever, and you found out, and you went to a physician, and you found that's the physician you wanted to walk you through this process, and you had to sign some consent forms. They were consent forms, or some type of prenatal consent forms, as some states call them, but they were consent forms nonetheless, and they granted that physician to do quite a few things on your behalf for the sake of the child. So basically, you granted power of attorney to that physician to do things, to act on your behalf. That was power of attorney that you granted them. Now, keep in mind. Well, we're gonna go into just because your child your child was in a state of incapacity. I'm gonna read that definition to start off with, so you can understand what that term actually means. Incapacity. As you see, incapacity means the inability of an individual to manage property or business affairs because the individual has an impairment in the ability to receive and evaluate information or make or communicate decisions, even with the use of technological assistance, or is missing or outside the United States and unable to return. It don't mean that this is what the baby is, okay? But this was definitely you when you were born. This is your baby when you were born. When everyone was born, they came into this world in this state, okay? As you get older and you become grown, you reach the age of consent. The age of majority, as we call it, as is legally known as the age of majority. This is you, and this is you. This is actually both of you, because if you don't know the law, this is still you right here. You still don't know how to do things properly, even when it comes to paying your bills, when it comes to doing things, when it comes to operating in court. You don't know the law. You don't know what to do. You used to hiring attorneys to do shit for you because you don't know what to do. You still have an inability to evaluate information, or make communicate decisions, even when with the technological assistance. You don't know how to do it. That's why you hire people to do it for you. You pay your bills through your Federal Reserve notes. There are other ways to pay your bills, but that's not what we're talking about. Okay, when you get served a document, you get served something to come to court. You don't file an answer into the court case. This is your status right here. This is your status. This is your status when you walk in there and you don't file shit into that court case before you get there. This is still your status. Incapacity. Okay? Now, so when you so recognize that term when you see that. Okay? Now, we're talking about a power of attorney right here. We're in Virginia right now, y'all. I'm gonna go to a couple other states, and I'm gonna show y'all that they all say the same damn thing. Some of them word them slightly different, but you're gonna see exactly what it does. We know what a power of attorney is. In case you don't know, we're gonna read this quickly. A power of attorney means a writing or other record that grants authority to an agent to act in the place of the principal, whether or not the term's power of attorney is used. See what I'm saying? So it don't have to be called a power of attorney, and it don't have to be in writing. It don't have to be something that the principal actually wrote up. It could be or other record. The birth certificate is a record. Notice whose name is written on that birth certificate other than the father and the mother. The physician is also written on that document, and there are other people written on there too that work for the state. All of them work for the state. Okay, so their names are written on there. Okay, I'm breaking this down, trying to make it in layman's terms, so simple language, so we can get it. Now, let me roll on down to. I don't want to go through all the rest of that. I'm gonna show you something real quick. Power of attorney. When a power of attorney effective? Yeah, this is it. A power of attorney is effective when executed. Is effective when executed unless the principal provides in the power of attorney that it becomes effective at a future date or upon the occurrence of a future event. Y'all know that's what you call a springing power of attorney. In case you don't know that, a springing power of attorney. That's what they did. That's what they just described. I want to pause for a second and show you. See, springing power of attorney, a person whose name can be immediately. Let's see, a power of attorney. Yeah, here we go. If your power of attorney includes limitations that one or more doctors must determine your incapacity in writing prior to the power of attorney being effective, it is a springing power of attorney. I don't like using random sources though. We all depend on Cornell. Springing power of attorney is a type of power of attorney that lasts when a principal is incapacitated. There's that word again, and does not take effect immediately. You see what I'm saying? It don't take effect immediately. And keep in mind, when the mother creates these, when she gives power of attorney to the physician, that power doesn't kick off until they don't start taking control like that until you're born. Keep in mind, it takes 9 months for her to actually give birth, but she does the paperwork before the physician actually starts doing his thing or her thing. So anyway, let's move forward. If a power of attorney becomes effective upon the occurrence of a future event or contingency, the principal in the power of attorney may authorize one or more persons to determine in a writing or other record that the event or contingency has occurred. Okay? If a power of attorney becomes effective upon the principal's incapacity and the principal has not authorized a person to determine whether the principal is incapacitated, that's the baby. The baby can't authorize nothing. Okay? Or the person authorized is unable or unwilling to make the determination. Baby mama drugged up. Let's not say baby mama. The mother is drugged up. She drugged up. She's on drugs. She's not in the right state of mind. She's stressed. She just gave birth to a baby. Okay? The power of attorney becomes effective upon the determination in writing by other record by the principal's attending physician and a second physician or licensed clinical psychologist after personal examination of the principal that the principal is incapacitated. That's the baby. Within the meaning of subsection 1 of the definition of incapacity. We read that already. Or an attorney at law, a judge, or an appropriate governmental official that the principal is incapacitated within the meaning of subsection 1 of the definition of incapacity in 64.2-1600. We just read that. Okay? So I want y'all to see that. This is where the original power of attorney starts, when you're first born. Okay? This is where it first started. This is the first power of attorney. Even if it's not you, even if they don't use the word power of attorney. I just read that to y'all. So, I don't like to sit here and just speak on things that I can't prove in what I'm showing y'all. I'm showing y'all what the law says. This is Virginia. A lot of these states, they actually word things differently, but they use the same principle. Why you think everybody's birth certificate or certificate of live birth can be used in any 50 state? You can still use it. It's valid. It don't matter. You don't have to go get it authenticated or nothing. You just take it there and use it. Okay, because it's valid. Okay, a person authorized by the principal in a power of attorney to determine that the principal is incapacitated may act as the principal's personal representative pursuant to the Health Insurance Portability and Accountability Act, 1171 through 1179 of the Social Security Act, 42 U.S.C. 1320D as amended, and applicable regulations to obtain access to the principal's healthcare information and communicate with the principal's healthcare provider. See, so I'm just showing y'all. I don't want to even go through the termination of a power of attorney because I done already been through all that. Y'all look at my previous video. The name of this video is the first power of attorney. That's what I'm naming this video. So I'm showing y'all where it all started. Bingo. Here we go. Now let's go to, this is Florida, the Sunshine State. Okay. Let's scroll on down. They use the same paperwork. The same. Let's see. Here we go. Let's start with short title definitions. I'm gonna scroll on down. Scroll on down. Incapacity is that word again. Same thing. The inability of an individual to take those actions necessary to obtain, administer, and dispose of real personal property, intangible property, business property, benefits, and income. Okay, saying similar definition, means the same thing but different, similar wording, but it's the same thing. Okay, definition, same word, same thing. Let's scroll on down. First power of attorney. Validity. Here we go. When a power of attorney is effective. Here we go. Except as provided in this section, the power of attorney is exercisable when executed. If a power of attorney executed before October the 1st, 2011, is conditioned on the principal's lack of capacity. Did they use the word capacity in here too? Did they use the word capacity? They didn't. They just used incapacity. But you get it. We know the difference. We know what it is. Okay. Here we go. Let me go back up here. Here we go. If a power of attorney executed, let me make this bigger so y'all can see. Let's see. Executed before October 11 of 1st, 2011, is conditioned on the principal's lack of capacity, and the power of attorney has not become exercisable before that date. The power of attorney is exercisable upon the delivery of the affidavit of a physician. There's that state agent again, who has primary responsibility for treatment and care of the principal, and who is licensed to practice medicine or osteopathic medicine pursuant to Chapter 458 or 459 as of the date of the affidavit. Does not sound like the same setup? This is the principal. The principal is the baby. Okay, taking care of the principal. When mother does the prenatal agreement before she gets started, holding the baby, going through the hold on a second. I'll hit you right back, big dog. I'm doing a video. All right, bye-bye. Okay, now the thing is, we have a right here, as you see, the physician is the one that's doing this. Okay, this is the physician. You see, it all starts with the physician, who's the state agent. Okay, the affidavit executed by the physician must state that the physician is licensed to practice medicine or osteopathic medicine pursuant to Chapter 458 or Chapter 459. That the physician is a primary physician who is the primary physician who has responsibility for treatment and care of the principal, and that the physician believes that the principal lacks the capacity to manage property. Okay, so we see that this is what it goes. It's the physician. This is the original power of attorney. That's the original one right there. except as provided in subsection 2, which is what we just read, and section 709.2106.4, a power of attorney is ineffective if a power of attorney provides that it is to become effective at a future date or upon occurrence of a future event or contingency. That's the day you were born. That's one good example. Okay, it's not limited to the day you were born, but it also includes the day you were born. There are many circumstances where this would apply, but it definitely applies when you were first born, because he can't take care of you until you come out of the womb. Okay, but the agreement was granted to the physician during the time when the mother finds out she was pregnant. She did the paperwork before the 9 months were up, when you were still in your mother's belly. Okay, so the physician can't act and take care of you, can't do anything on your behalf as far as your health care concerned. Can't do all that on another level until you're delivered from the womb. Okay, now let's go to another state. I'm right there. I read that at my own time. Let's do Minnesota. Here we go. Everybody familiar with Minnesota. Everybody jumped on them goddamn Minnesota assumed name certificates. Now we're gonna see what the hell I don't, just for the record, y'all, I don't support that no more. So don't call me, ask me about no damn Minnesota assumed name certificate, because that shit is obsolete to me. Okay? It's hit and miss, and it don't most of the time it don't work. Okay? And only if you don't live in Minnesota, you shouldn't be doing one anyway. But anyway, moving forward, that was just a side note. Here we go. Definition. Let's start with the definitions. So we can see they have the same definitions. Incapacity, there's that word. Means cause for appointment of a guardian or conservator of an adult under section blank blank. Those right there. There's a semicolon. A principal includes a guardian or conservator appointed for the principal at any time. And power of attorney means validly, executed power of attorney. Let's see, capacity. They talking about an adult right there. See, calls for an appointment of a guardian or conservator of an adult under. Let me click what this says. Protected proceedings. Cited as Uniform Guardianship and Protective Proceedings Act. I'm trying to stay on course, y'all. I don't want to get thrown off. Compensation expenses. This talking about the court and everything. Court reimbursement. I'm not gonna get off into that. Okay, let me back up. I don't want to get caught up into that. Here we go, because I get to studying, y'all. I've been around to get thrown off from the fact that I'm recording a video, and I start studying off into some other shit. But I'm gonna stay focused right here. Okay, here we go. Durability certification. Which one of these was I gonna read? Not termination. Power of attorney, revocation of a power. Effectiveness. Where is it? Presumption. Let's see. Valid execution. Recording. Certification. What was it? Was it certification I looked at? No. It's not that. Durable power of attorney. Effectiveness. Which one was it? Let me just click on all of them. We'll see. Expiration. Termination. Missing person presumed living. That was crazy. That caught my attention before I started recording, y'all. Let's see. I should have left it where it was. Affidavit of proof. Attorney, in fact, it's got to be up here at the top, up here somewhere. Revocation of a power. We know about that. You know you got to revoke it. Actual notice. That's not. I don't want to read that yet. Let's try it. Let's do valid execution. Let's see. Is this it? Let's see. A written power of attorney that is dated and purports to be signed by the principal named in it is presumed to be valid. All parties may rely on this presumption except those who have actual knowledge that the power was not validly executed. That's not what I'm looking for, but that's good to know. Oh, authorization. Let's read what that says. Authorization. Let's see. We're talking about power of attorney. Let's see. A person who is a competent adult as a principal, may as a principal designate another person or authorized corporation. This is not what I'm looking for. We ain't talking about no adult. We're talking about kids. I'm talking about the first power of attorney, y'all. The first one. Let me click on here. I might have clicked on the wrong part. Fiduciary, let's see, trust, and that was it. I was on the right spot. I read it right before I hit record. I don't know what the hell I'm looking for now. I should have just left it where I was at. Termination. Expiration of the date of a power of attorney. Expiration date. Due of a power of attorney. Let me just click on this here. Because it's still talking, I think it was talking about an adult incapacity. Principals later incapacity. That could be an adult who's incapacitated, because they say later, principals later incapacity or incompetence. That could be an adult. I'm talking because I'm trying to keep it stuck on I'm trying to keep it where the it's a reason why I left this on Minnesota. Let's see, recording, presumption of valid. Let me see. Did I just read this already? Yeah, I did that. I did that one already. Recording, yes, you're supposed to record it. If the exercise of power of attorney requires execution and delivery of any instrument which is recordable, the power of attorney and any affidavit authorized under section 523.1 to 523.24, when authenticated for record in conformity with section 507.24, are also recordable. Okay, now we already know that in some other states they say you're supposed to record a power of attorney as well. So Minnesota, as we can see, you can record it. Y'all know that word there, authenticated, make me want to go back to the definition so y'all can get a clear definition. Every time somebody hear the word authenticate, they think about authenticating a birth certificate. And so matter of fact, I'm gonna go back and see what we're gonna see. I'm gonna see something about that. Authenticate. What does it mean? I forgot. I didn't even have it written in there. Okay, we ain't gonna worry about that. Let's stay on topic. Durable power of attorney. I clicked on that already. Termination. You know what? Fuck it. I ain't gonna even worry about it. Let's see. Because it normally has where's the part? I'm missing the part that I'm looking for. Power of attorney of expiration. Say in the power of attorney, an expiration date, if any, must be stated in terms of specific month, day, and year. An expiration date stated in any other way has no effect. Okay, so it don't expire unless you put a date in there. Okay, missing person. I didn't want to read that one. I'm just gonna read the revocation of power since I can't find what I'm looking for. I'm just gonna read it so you can still have some content and actually understand. You get something out of me being on Minnesota. I told you this stuff reads differently. Some any action taken by the attorney, in fact, pursuant to the power of attorney, binds the principal. The principal's heirs and assigns and the representative of the estate of the principal in the same manner as though the action was taken by the principal, and during any time while a guardian or conservator has been appointed for the principal. And only the guardian or conservator has the power to take relevant action, as though the action was taken by the guardian or conservator. As you can see right here, power of attorney, all these different when it starts with the physician, and now a conservator can be assigned to you, or guardian. At any, they can just serve as your representative, the representative of the estate of the principal. Your name in all caps is the name of your estate, y'all. You the principal, that's the name of your estate. Okay, so understand that. Representative of the estate of the principal. Okay, so they're representing your name on your behalf. Okay, let me back up. But anyway, let's go. I know y'all probably curious to see what this thing says. It don't say nothing. It say, for the purpose of this chapter, a missing person is presumed to be living until actual proof of death or legal adjudication of death occurs. I've never seen that written in no other state where it says a missing person is presumed living. That's the first time I've seen that. Most people, they say, is presumed dead. But even though in another part of this in Minnesota, they do have a presumption of death situation. It's in the states, the part where they talk about estates. So they don't talk about that in this chapter. Okay, revocation of power of attorney. I think I've read that already. Bind and qualification. Let's see. Attorney in fact. Let me see what it says about the attorney in fact. Oh, this might be a little something. Unless it is provided to the contrary in a power of attorney which authorizes two or more attorneys in fact to act on behalf of a principal, any action taken by one of the several attorneys in fact pursuant to a power of attorney, as you see right there, it don't have just they got multiple people representing your name. Several attorneys, in fact, pursuant to the power of attorney. So it don't start with it don't stop at the physician. It starts at the physician. But as you see, they got multiple people that can be delegating power over your affairs. Okay, to the power of attorney, rather the other attorneys in fact consent. See, rather the other attorneys in fact consent or object to the action binds the principal. It binds the principal either way, whether they consent to it or not. It don't matter. They even button heads. It says the principal's heirs and assigns, and it says and the representative of the estate of the principal in the same manner as though the action was taken by the principal. So it still binds the principal. Everything they do, it binds you. It binds the principal. All these people represent your estate. They're all acting on your behalf, on behalf of the principal. It don't matter whether they agree to it or not, whether other attorneys in fact consent or not or object. It still binds the principal. As you can see, it says that. Did you see that for yourself? Okay, the principal's heirs. Let's see. And during any time while the guardian or conservator has been appointed for the principal, and only the guardian or conservator has the power to take let me read that. During any time while the guardian or conservator has been appointed for the principal, and only the guardian or conservator has the power to take the relevant action as though the action was taken by the guardian or conservator. Okay, this is crazy, man. These folks, they just do all kind of stuff when it comes to your estate. Qualification of a successor. So, but anyway, I wanted to try to stick on the first power of attorney, but Minnesota, the way they word their stuff kind of caused me to kind of throw off a little bit. So I'm gonna see what I can read with this part right here, and I'm gonna close with this. The principal may be the principal or any interested person as defined in section 524.5-102, subsection 7 may petition the court for protective order directing an attorney in fact to provide an accounting on a schedule directed by the court, or for the relief or other relief as provided in section 524.5-401 to 524.5-502. The principal or a person named by the principal in attorney in fact to receive accounting is entitled to recover reasonable attorney fees. Okay, this ain't what I'm looking for anyway. But I'm gonna get on out of here, y'all. I just thought I'd make the little video so I can actually show y'all where the actual thing starts. Let me see. It was a reason why I stopped this here. This was actually something else right here. Healthcare, power of attorney, financial matters, durable attorney in fact, healthcare. What state is this? What state is this? This is what NRS? Yeah, this is Nevada right here. Yeah, this is Nevada. right here. Capacity right here. Incapacity. Incapacity means the inability of an individual to manage property. See, as you can see, it's the same document. To manage property or business affairs because the individual has an impairment in the ability to receive and evaluate information or make or communicate decisions even with the use of technological assistance, or is missing. There's that word again. Detained, including incarceration or in a penal system or outside the United States and unable to return, as determined by a court of competent jurisdiction, or if an instrument executed. See, this is what's determined by the court. It tells you that. As long as you're considered incompetent because you missing, you ain't filed no type of answer to the court case, this is going to be the determination of the court. Say, or if an instrument executed pursuant to this chapter specifically provides a different method for determining the incapacity of an individual for the purpose of this chapter, as determined by the method set forth in that instrument. Yeah, nothing else, but this is what's going to be. As long as they see you like that, this is going to be the determination. When they see you as in the state of incapacity, you're incompetent. This is the state that they have you. This is the status they give you right here. You're missing incapacity. Okay. Now, as going down, let's see termination of power of attorney. Let's see effective power of attorney. Once they can kick in, let's see. Effective of power of attorney. Let's see, meaning the power of attorney determined by the law of the jurisdiction indicated that ain't what I was looking for. Effective power, that ain't what I was looking for. Validity, power, execution, certain. Let's see, durable, that's not what I'm looking for. Meaning effective power. Time power, here it is right here. And I'm going to close with this. This one I'm going to close with, y'all. I keep saying I'm going to close, but I'm going to close with this. Okay. Time at which a power of attorney is effective. This is Nevada, y'all. This is the last state. But they all saying this shit. They got it hidden. Minnesota got it hidden some type of way. I ain't finna go through all them damn things looking for it. But anyway, a power of attorney is effective when executed unless the principal provides in the power of attorney that it becomes effective at a future date or upon occurrence of a future event or contingency. If a power of attorney becomes effective upon occurrence of a future event or contingency, the principal in the power of attorney may authorize or more persons to determine. May authorize one or more persons to determine in writing or other record that the event or contingency has occurred. If a power of attorney becomes effective upon the principal's incapacity, and the principal has not authorized a person to determine whether the principal is incapacitated, you sure didn't. Or the person authorized is unable or unwilling to make the determination, the power of attorney becomes effective upon determination in writing or other record, birth certificate, by the or whatever record, by an advanced practice registered nurse, a physician, psychiatrist, or licensed psychologist that the principal is incapacitated. A person authorized by the principal in the power of attorney to determine that the principal is incapacitated may act as the principal's personal representative pursuant to Health Insurance Portability and Accountability Act of 1996, Public Law 104-191. I need to look that up on when I stop this video. I'm gonna look all three of them up really, but I already wrote those down. Okay, as amended and applicable relations to obtain and determine a determination of incapacity. And I'm gonna stop right there, y'all. As you can see right there, the first power of attorney starts with your mother. It starts by what our mothers granted them, what granted the physician. or with the with the consent. When she did that, the power of attorney was kicked off, and when it came into effect when you were born, and that's when they were able to start doing all the things they're doing all your life until you rebut it. Okay, I might want to even do that. Termination of the power of attorney or authority of agent. A power of attorney that terminates when the principal dies. That's when you die. You don't die with a will or whatever. There's no will. You see, they even do that old stuff when you're after you're dead. So the principal becomes incapacitated if the power of attorney is not durable. The principal revokes the power of attorney. This is your solution right there. This is your solution. The power of attorney, I'm gonna stop right there. Well, I don't need to read the rest of that. The agent's authority terminates when the principal revokes the authority. See, you need a power of attorney, a new power of attorney that specifically revokes their power of attorney, and you gotta serve them. Okay, termination of an agent's authority. Say, unless the power of attorney or otherwise provides an agent's authority is exercisable until the authority terminates under Section 2. Notwithstanding the lapse of time since the execution of the power of attorney. Termination of an agent's authority or of a power of attorney is not effective as to the agent or other person that without actual knowledge of the termination acts in good faith under the power of attorney. An act so performed unless otherwise invalid or enforceable. Binds the principal and the principal's successors in interest. You have to serve them. You got to serve them nully. That's the only way they're going to have actual knowledge of the termination. You have to serve them. Okay. Incapacity. The incapacity of the principal of the power of attorney that is not durable does not revoke or terminate the power of attorney as to an agent or other person that without actual knowledge of the incapacity acts in good faith under the power of attorney. Any act so performed unless otherwise invalid or unenforceable binds the principal and the principal's successors in interest. The execution of a power of attorney does not revoke the power of attorney previously executed by the principal unless the subsequent power of attorney provides that previous powers of a power of attorney is revoked, or that all other powers of attorney are revoked. You have to state that in your new power of attorney. When you create a new one, you have to state that in there, and you have to serve it to them in order for it to be valid. That's how you shut down the power of anybody administering your estate without your consent. You revoke the power of attorney. If you haven't liked and subscribed, please do so now. Y'all can't say I didn't show y'all some good shit today. I'm loving this shit. I swear, y'all, I love it. But like and subscribe, hit the notification bell, because we're going to keep going with this, okay? Share this video with your people. Share it with people you know that's fighting these court cases and wondering where these people get the power from. They can't administer your estate until when you revoke their power. But they're operating all types of things. You see, I showed y'all where they delegate all types of powers. They can have multiple powers of attorneys operating on your behalf, even if they don't even agree with each other. They can still do it. It says it. You just saw it for yourself. So y'all know what y'all got to do. You know what you got to do. So go ahead and like and subscribe, and I'll see y'all in the next video. Emerald.